Good evening to the participants of the SLW670. This is a blended mode class on 25th November 2022. Yes, anyone can unmute and read what I posted on the screen. Participants, anyone can unmute and read what I posted on the screen. Intellectual property refers to the creation of the mind, inventions, literary and artistic works, designs and symbols, names and images used in commerce, and deliberated by the Professor Dr. Mohammed Saheb Hussain, Professor of Law, School of Law, St. Augustine University of Tanzania, Malimbe, Mwanza, Tanzania, East Africa. So without wasting the time, let me go to our studies concern, and this is the thing that you would like to make it out. Of course, TRIPS also we have to see it, because if you happen to see the syllabus, there's a course content, legal framework, and the influence of the TRIPS agreement on the international agreements and the Tanzanian intellectual property law. Then how the TRIPS agreements will play a role, let us see that what actually the TRIPS agreement says regarding the intellectual property is concerned. So, intellectual property protection and enforcement, when you want to see it, the WTO agreement on the trade related aspects of the intellectual property rights, there's a TRIPS negotiated during the 1986-94 Uruguay round, introduced the intellectual property rules into the multilateral trading system for the first time. So TRIPS agreement is the landmark of the WTO, and which will bind all intellectual properties rights are concerned. And here it is given the content, the basics, agreement, overview up to the more introductory information, the WTO. Let us see the WTO in brief, the origin into the rule-based trading system. The idea of trade and what makes the trade valuable for the societies has evolved beyond the simply shipping goods across the borders. Because the most of the trading would be done by shipping, but not by road or by flight. So innovations, creativity, and branding represent a large amount of the value that changes hands in international trade today. So there are a lot of innovations are there, creativity of man, and the branding, the product, the large amount of the value that exchange changes hands in international trade today. How to enhance this value and how to facilitate the flow of knowledge, rich goods and services across the borders have become an integral consideration in development and trade policy. So the intellectual development and trade policy, the inventions, trade, merchandise, and there would be a need of the trade policy to control these innovations and its rights. The TRIPS agreement plays a critical role in facilitating the trade in knowledge and creativity. So this agreement made a critical role in facilitating the trade in knowledge and creativity in resolving the trade disputes over intellectual property. If any disputes should be there over the intellectual property, so the TRIPS will resolve it, and it will act as a mediator and resolve the problem, and assuring the WTO members that the latitude to achieve their domestic objective. So each country, those who are the members of the WTO, and for their interest to be protected if any country exploits the innovatory rights of a particular country. The agreement is legal recognition of the significance of links between the intellectual property and trade. So TRIPS agreement is a significance shows that the links between the intellectual property and its innovations, that is a trade. So let me see the further participants. Are you there? So if you want to see that the agreement legally property and trade is intellectual property refers to the creation of the mind. The intellect means thinking of the mind, and the creation of the mind is the intellectual property. These creations can take many different forms, such as artistic expressions, signs, symbols, and names used in the commerce, designs, and inventions. The government grants a creator the right to prevent others from using their inventions, designs, and other creations, and to use that right to negotiate payment in turn for others using them. So the government will create a grant. See that if a person who invented his own product, he could enjoy it. The other person should not enjoy it, but he can sell the rights to other person to enjoy it, and thus he can create some finance. And to use that right to negotiate payment, suppose somebody wants to use that, so they can negotiate the payment in turn for others using them. So if they agreed for the terms and conditions, let the others may using them, the product which is invented by him. These are the intellectual property rights. They take a number of forms. For example, books, paintings, and films come under the copyright. Eligible inventions can be patented. If any inventions are there, it can be patented. Brand names and product logos can be registered as a trademark. The logos are there and product logos are there, so it will be registered as a trademarks and so on. Government grants a creator these rights as an incentive to produce and spread ideas that will benefit the society as a whole. The society as a whole will be benefited if such a rights are guaranteed to the person who is the creator of the particular product. So the extent of the production and enforcement of these rights varied widely around the world. If a person is the inventor of a product, yes, it is exclusively right of him to use it. Suppose somebody wants to use the product, let them negotiate it and buy it so that the inventor could get some revenue. Around the world, and as intellectual property became more important in trade, these differences became a source of tension in the international economic relation, because somebody invented and somebody is enjoying. That means exploiting the somebody's intellectual property. New internationally agreed trade rules for intellectual property rights were seen as a way to introduce more order and predictability and to settle the dispute more systematically. So there would be agreed trade rules for the intellectual property rights, which were seen a way to introduce more order and predictability and to settle the disputes more systematically there, because that is the significance of the TRIPS. The Uruguay round achieved that WTO's TRIPS agreement is an attempt to narrow the gaps in the way these rights are protected and enforced around the world, and to bring them under the common international rules and the common platform. It established the minimum standard of production and enforcement that each government has to give the intellectual property held by the nationals of the fellow WTO members. So, who are the WTO members would be there, and for them, this TRIPS agreement will facilitate to enjoy the invention of particular state or by the individual himself or the state itself, and other could not enjoy it. If they want to enjoy the benefits of it, then they have to borrow and negotiate with the creator, and then can enjoy the product. Under the TRIPS agreement, WTO members have considerable scope to tailor their approaches to intellectual property protection and enforcement in order to suit their needs and achieve the public policy goals. So the member states, those who are there in WTO and agreed for the TRIPS agreement, then all the disputes regarding the various IP produces over there, that will be protected and the dispute could be resolved. The agreement provides a ample room for the members to strike a balance between the long-term benefits of incentivizing or innovations and the possible short-term cost of limiting access to creations of the mind. There are long-term bases are there, short-term bases are there, but both the way it will be the incentive to the inventor. Cost limiting the access to creation of mind. Members can reduce short-term costs through various mechanisms allowed under TRIPS provisions, such as exclusions or exceptions to intellectual property rights. And when there are trade disputes over the applications of the TRIPS agreement, the WTO dispute settlement system is available. So there is a dispute settlement system is also available over there when such a states violates the rights of the inventor or a creator, or that instance the steps should be taken to resolve such a dispute by following the norms of the TRIPS. The TRIPS agreement covers five broad areas. What are the five broad areas the TRIPS agreement covers? The first bullet, let us see how general provisions and basic principles of the multilateral trading system apply to the international intellectual property. So, number one is how general provisions and basic principles of the multilateral trading system apply to the international intellectual property. Number one bullet. Second bullet, what are the minimum standards of the production or of intellectual property rights that members should provide. So minimum standards of the production of intellectual property rights that the member should provide. Third bullet, which procedure members should provide for the enforcement of these rights in their own territories. So it is the mechanism for the enforcement, the members' right in their own territories. And one, two, three. The fourth bullet is how to settle disputes on intellectual property between the members of the WTO. So how the nature of it, the disputes will be resolved on the intellectual property between the members of the WTO. The last bullet is special transitional arrangement for the implementation of the TRIPS provision. So there is a special any transitional arrangement would be there as a special case in the implementation of the TRIPS provisions. In these five broad areas, the TRIPS agreement covers. So now let us see the basic principle. What is the basic principle would be there? Okay. So basic principle, let me close. Okay. The basic principle, national treatment, MFN, and balanced production. So as in a general agreement on tariffs and trade, there is a GATT. Is a general agreement on tariff and trade, GATT, and the general agreement on trade services, GATS. The starting point of the TRIPS agreement is basic principles. So these are two general agreement, and the starting point is the TRIPS agreement is a basic principle for this GATS or GATT. As in the two other agreements, non-discrimination features prominently national treatment, that is treating foreign nationals no less favorable than one's own nationals, and the most favored nations, MFN. Most favored nations treatment, not discriminating among our nationals of trading partners. So national treatment is also key principles in other intellectual property agreements outside the WTO. So, most favored nations, MFN, that is a treatment not discriminating among the nations of trading partners. There would not be any discrimination of the trading partners where the intellectual property agreements outside the WTO, even it is outside the World Trade Organization. The TRIPS agreement has an additional important general objective. Intellectual property protection should contribute to the technical innovations and the transfer of the technology. Why all these things should be needed? It is nothing but to protect the property of an intellectual and who is a creator. So nobody would exploit such a creation unless until it will be paid something to him to enjoy such a creator's knowledge. So, general objective is concerned, intellectual property protection should contribute to technical innovations and the transfer of technology. There is a technical innovations and transfer of technology. These are the must. And both the producers and the users should benefit. And the economic and the social welfare should be enhanced. The TRIPS agreement says. That is the motto and the objective of the TRIPS agreement is let the property, the creator and his knowledge will be shared by paying some negotiation with him and get the benefit of it by paying some revenue, the money. And the innovations, the transfer of technology is there, and both producers and users. A producer means a creator, and users means beneficiaries, those who are using such a technology or product. Users should benefit, and economic and social welfare should be enhanced. The economic and social welfare of people should be enhanced. That is the TRIP agreement says. Then, how to protect the intellectual property? Repeat, how to protect the intellectual property? That means common ground rules. What are the common ground rules should be there to protect the intellectual property? The second part of the TRIPS agreement looks at different kinds of intellectual property rights and how to protect them. The purpose is to ensure that minimum standard of production exists in all the WTO members. So, the purpose is to ensure that minimum standard of production exists in all WTO members. So, minimum standard would be protected all the members of the WTO. And here the starting point is the obligation of the main international agreements of the World Intellectual Property Organization, that is WIPO. So all the nations, those who are members of this WIPO, they should have to follow all the norms of it, and that already existed before the WTO was created. So WIPO was first, and then later on the WTO, and the WTO creation is the TRIPS. So now let us see some conventions created by the WTO. WIPO that already existed before the WTO was created. So let us see how it works. The Paris Convention for the Protection of Industrial Property, that is the patent and industrial designs. Excuse me. Patents and industrial designs are protected by the Paris Conventions. The Berne Convention for the production of the literary and artistic work, that is the books and dissertations and papers, or yes, such nature which is literary and artistic nature, so that will be protected by the Berne Conventions. And some areas are not covered by these agreements. In some cases, the standard of production prescribed were the third inadequate. So the TRIPS agreement adds significantly to existing international standards. So what are the existing standards now prevailing in the trade and business? The TRIPS agreements will follow such standards. So copyrights are concerned. It is one of the intellectual properties, the copyright. Copyright usually refers to the rights of the authors in their literary and artistic works, either prose, poetry, or research, or books, anything, or the artistic work is there, or a painting is there, or something which will be on the paper. So these are all protected if he invented a thing, that is a copyright. In a wider sense, copyright also includes related rights, the rights of performance and performers or producers or phonograms and broadcasting organizations. These are all come under the copyright. The rights of the performers and producers of phonograms, gramophones, and broadcasting organizations. These are all come under the copyright. During the Uruguay round negotiations, members considered that standards for the copyright production in the Berne Convention for the production of the library and artistic works were largely satisfactory. So the TRIPS agreement provisions on copyright and related rights clarify or add obligation on a number of points regarding the copyrights. So the first bullet is the TRIPS agreement ensures that the computer program will be protected as a literary work. So computer programs are considered as a literary works under the Berne Conventions and outline how database must be protected under the copyright. The second bullet, it also expands the international copyright rules to cover rental rights. So author of the computer program and the procedure of the sound recording must have right to prohibit the commercial rental of their works to the public. So similar exclusive right applies to the films where commercial rental has to lead to be the widespread copy, affecting the copyright owners' potential earnings from their films. And the last bullet is it says the performers and must also have the right to prevent the unauthorized recording. So unauthorized recording will be protected over there. So if a producer produces a movie and there is no pirated copy, if the pirated copy would be there, naturally the producer who spent that much money, he could not get it back. And he became a pauper. So reproduction is concerned, recording is concerned, and broadcast of live performance is concerned, that is a bootlegging for no less than 50 years. And producer of the good sounding or recording, sounds and recording must have the right to prevent the unauthorized production of the recording for a period of the 50 years. So 50 years time period is given. So after 50 years that copyright will be vanished or no more in existence. So that is about the copyright is concerned. Participants, are you hearing me? Nobody is participating in my discussion. So next is trademarks. A trademark is a sign or a combination of signs used to distinguish the goods or services of one enterprise from another. So that is a trademark. I repeat, a trademark is a sign or a combination of signs used to distinguish the goods or services of one enterprise from another. So now let us see how the TRIPS agreement defines what type of these signs must be eligible for the protection of the trademark, and that what minimum right conferred on their owners must be. It says that service marks must be protected in the same way as the trademarks used for the goods. Marks that have become well known in a particular country enjoy the additional protection. So that is an advantage of this trademark. So now let us see the geographical indications. So a name or indication associated with a place is sometimes used to identify a product. This geographical indication does not only say where the product comes from, more importantly, it identifies the product's special characteristics which are the result of the product's origin. So the products which came and that origin will be named under the geographical indications. So well-known examples include champagne, it is Scotch whiskey, tequila, Darjeeling tea, Roquefort, cheese. So these are all a trademark. Sorry, geographical indications. So a Darjeeling tea is very famous in India. And if you see, Kerala rice is famous in Tanzania. And Spice Island is said to be the Zanzibar. And if you go on saying that tomatoes is grown morely in Iringa, so Nanya is starting in the Iringa. So the indications where the product is mostly grown will come into the picture, and that is called as geographical indications. Using the indications when the product was made elsewhere or when it does not have the usual characteristic can mislead the consumers and can lead to the unfair competition. Suppose we can say that a nyanya is from the Iringa, but the nyanya which is grown in the Morogoro and the rest of the place, they say that it is exported from the Iringa, but which is a false. Then such benefit will not be available to the parties. So using the indication when the product was made elsewhere or when it does not have the usual characteristic can mislead the consumers and such lead to unfair competition. So the TRIPS agreement says members have to provide ways to prevent such a misuse of geographical indication. So for preventing such a misuse, the TRIPS agreement will play a role under the guide of under the caption of the geographical indications. For wines and spirits, the TRIPS agreement provide higher level of protection. That is where even where there is no longer no danger of the public being misled. So public will not be misled by using such a geographical name. Some exceptions are allowed. For example, if the term in question is already protected as a trademark or if it has become a generic term. So some things protected by trademarks or if it has become a generic terms, the TRIPS agreement provides for the further negotiations in the WTO to establish a multilateral system of the notification and registration of the geographical indication for wines, which was subsequently extended to include the spirits. The question of whether to negotiate extending this higher level of the production beyond the wines and spirit is also being discussed in the WTO. So WTO will make the discussion on the how it can be made in the geographical indication, and through the TRIPS agreement, then we can make it out. So, and here we would like to see how the TRIPS agreement will protect the geographical indication so that the people will not be misled. Now let us go to the industrial design. So participants, are you with me? So industrial designs are concerned, let me see it. Industrial designs is generally understood to refer to the ornamental or aesthetic aspect of an article rather than its technical features. I repeat, industrial design is generally understood to refer to the ornamental or aesthetic aspect of an article and rather than its technical features. So, under the TRIPS agreement, original or a new industrial designs must be protected for at least 10 years. Like artistic work, I told you that is the 50 years, but here the industrial design is at least for the 10 years will be protected. And the owners of the protected design must be able to prevent the manufacture or sale or transportation, importation of the article bearing or embodying the design, which is a copy or substantially a copy of the protected design for commercial purposes. So, if a person has invented a design or made a new design, so it will be a copy, there will be an industrial design and whose production will be for 10 years, so that the other people cannot exploit the design and make use of it. Then the patents comes later part. So it is also intellectual property and created by the intellectual of a man. So the TRIPS agreement says patent protection must be available for the eligible inventions. If any new invention is there, for instance, invention of the new variety of the rice, yes, there would be a patent. If in all the fields of technology that are new, involved in inventive step, then can be industrially applied. So eligible inventions includes both the product and process. So they must be protected for at least 20 years. However, the government can refuse to make, yes, the government can refuse to issue a patent for an invention if it is sale, if its sale needs to be prohibited for the reason for the public order or morality. So the patent should not be sold out without the consent of the owner, and hence the rights will be protected under the TRIPS agreement is for the 20 years. They can also exclude diagnostic, therapeutic, and surgical methods, plants, animals, other than the microorganism, and biological process for their production, other than the microbiological process from the patent production. So that patent production would be there definitely, otherwise they will also make use of the microorganism and producing the biological process, the products. So such a microbiological process from your patent will be protected. The plant varieties, however, must be protectable by the patent or by a special system such as the breeder's right provided in the Convention of the UPO, the International Union for the Production of the New Varieties of the Plants, or by both, that is AUPOV. So it means International Union for the Production of the New Varieties of Plants. So that also we protected under international way. The TRIPS agreement describes the minimum rights that a patent owner must enjoy. The TRIPS agreement describes the minimum rights that a patent owner must enjoy and defines the condition under which exceptions to these rights are permitted. So, naturally, if a person is an inventor, but his intellectual property right will be protected and somebody will not enjoy it without paying any penny to the inventor. Participants, are you there? Only 5 minutes are left. The agreement permits the government to issue the compulsory licenses and which allows a competitor to produce the product or use the process and license without the owner's consent, but this can only be done specific conditions set out in the TRIPS. The specific conditions are set out in the TRIPS. At the time only it could be undertaken. The agreement aimed at safeguarding the interest of the patent holder. So, who is the patent holder would be there. The TRIPS agreement, by virtue of the TRIPS agreement, his rights and interests are protected. If a patent is issued for the process of invention, then the right must be extended to the product directly obtained from the process. Yes, if the patent is given for the process and its product also should be given the process. Product also be protected through the process. Under certain conditions, alleged infringers may be ordered by a court to prove that they have not used the patented process. But sometimes no, they will make an allegation, or the allegation can be rebutted, but they said that they did not follow the patented process, but used the different process of it. Compulsory license for the export of medicines. So a person who wants to export for the medicine, he should need a license. And then design of integrated circuit, we will see it in the next class, but the time is going to up, and the participants, they are not giving at least one reply today. I don't know what was the reason, and let me see the layout design of integrated circuits. We can start in the next class. So by this, we would like to wind up my first period of the Friday of the Advanced Intellectual Property Law, that is the SLW670, if I not be mistaken. So asante sana, nashukuru sana, Mungu akubariki na kukulinda. Sikiliza mimi darasa, asante sana na shukuru sana, Mungu akubariki na kukulinda.